been in the news quite a bit, especially after WannaCry at the end of last week. And I know folks have called us with a lot of questions about it. We'll touch on some of those as we go. A quick overview. We're going to touch on some basics, what must be protected, different types of privacy incidents, defining a breach. What is a breach? You're going to hear us say a number of times, do not use the B word. We have a data incident until legal tells you that there is actually a data breach, and the reason is because the word breach has legal significance. We'll also talk about some proactive measures to minimize the risk of a breach, some different cyber trends within public entities, some real-world data breach examples. We like to tell stories as we go, keeping the names of the innocent obviously off the call. But we find that that's a great way to learn how other entities have dealt with particular situations and what they've faced, as well as talking about the incident response process. And then obviously we've got some time for Q&A. I'll turn it over to Dom.
Thanks, Jim. Yes, we'll start off kind of with, what generally is the type of data that needs to be protected, and most of this comes from the data breach notification statutes, which there are 48 of the 50 states that have breach notification laws. New Mexico just came on board, so we are left with South Dakota and Alabama holding out. And the important thing there is that we have to look to the state of residency of each affected individual. That's the law that governs. So even though the municipality, the city, what have you, the public entity may be situated within a certain state, the law that governs is the state of residency of each affected individual. So even on smaller incidents, we are often dealing with many, many state laws. And the state laws are very different with respect to what type of data must be protected, and they also differ as to their definition of a data breach. So it's really important that we figure out what states are in play, because that's going to determine what laws we have to look at. But generally, personally identifiable information or personal information, or you may hear it called PII, all of these in combination with first name and last name. So, of course, the usuals of Social Security number, driver's license, credit and debit card info, your financial account information. It gets a little more interesting as you go down the list: medical information, mother's maiden name, fingerprints, right, biometric, retina data, and email, username, and passwords. That was exploited in the recent Yahoo breach, and so that's why many of you probably got notice of that breach, because many of the states now include usernames and passwords, or email addresses and passwords, in their definition. So more and more data points are being considered as PII, so we're hearing about more and more data breaches. That's from the state perspective. We have various federal laws that entities need to be aware of. And by the way, there is no immunity. We get this question all the time from pools, from public entities, municipalities. There is no immunity from the breach notification laws. In fact, many of the states have a slightly more onerous statute for public entities, agencies, municipalities, public entities. So there's definitely not immunity from breach notification. There could be some immunity that could be exerted in litigation and in third-party defense. But from the breach response perspective, yes, you're certainly on the hook. So that we went through the state laws. The federal perspective, certainly HIPAA is one that often comes into play. And we often see where public entities don't realize that they're either a covered entity, because they think it's just hospitals, health systems, doctors' offices. Certainly those are all covered entities, but to the extent that the public entity is a self-insured plan under HIPAA, that would bring them into the realm of a covered entity under HIPAA. But more often than not, public entities may see themselves as business associates in which they have a relationship with a covered entity, and that also brings them under the purview of HIPAA. So we have state laws, we have federal laws, and then we have private standards. To the extent the public entity accepts, maintains, stores, transmits credit card information or debit card information, then the PCI, the Payment Card Industry Data Security Standards, PCIDSS, come into play. And these are private standards brought on by the card brands of Visa, MasterCard, Amex, and Discover. and certainly they have their own definitions of the type of personal information that they're worried about, of course, account numbers and CVV and expiration dates and PINs for debits. And the important thing here is when there is payment card information that is potentially at risk, it really accelerates the timeline. Under the states, we typically have 15 or 30 or 45 days to give notice. Under HIPAA, we have 60 days. When you're dealing with payment card data, Visa, MasterCard, they want notice within 2 days, 3 days. And so it really accelerates the timeline. And it's important, we'll talk later, some proactive steps that you can be taking. But it's really important that you have an incident response team in place and an incident response plan in place so that you are able to respond pursuant to these standards. It's very difficult to respond within 3 days with all of the information that is being requested if you have not assembled the team and have a plan in place. I love this cartoon because we hear all the time, you know, our IT is great, they have the best security and safeguards, we have firewalls, and we use encryption, and we have the best in antivirus software, and that's great, right? We have that in the one corner of the boxing ring. And then in the other corner, we have Dave with the human error t-shirt on. Probably 90% of the breaches and incidents that we help our clients through, we can attribute back to human error. It's an employee or some other third party clicking on an attachment, clicking and opening that document, clicking on a link, leaving the laptop on the front seat of their car, and the car is either stolen or broken into, saving things where they shouldn't be on an unencrypted drive, inadvertently sending data, personal information to the wrong party. So whether it's negligence, recklessness, gross recklessness and negligence, oftentimes we can attribute it back to that human error, that human component. So you're never going to totally eliminate this risk, but with constant training and cyber awareness and building that culture within your entity of cyber awareness, you really can reduce the risk of these situations. Kind of going in line with the human error, we have the top 10 passwords in breaches of 2016. You can see they were not too creative. Lots of strings of numbers, numbers in a row, 1, 2, 3, 4, 5, 6. Football, baseball, so some sports. We had a client the other day used password with $2 signs instead of 2 S's. They thought that was a really good password. Unfortunately, after the word password, the hackers probably tried $2 signs instead of 2 S's. So just constant awareness, again, in front of your employees, in front of your third parties that have access to your systems, because they can be the most secure. But if you're using weak passwords like these, they can be brute forced, and the hackers are very good at obtaining credentials and getting into very secure systems and appearing to be an authorized user.
Now, as Dom talked about human error, and really, unfortunately, our greatest threat is from within. It's our own people. So as we talk about the different types of privacy incidents, you'll see the thread throughout that it certainly does relate back to our people. The first is physical loss, and this is really the most common. You know, lost and stolen devices, laptops, PDAs, thumb drives, any type of portable media. And we see a lot of this. And, you know, also as a warning, when we talk about malware and ransomware, something that we've been seeing a trend is that these hackers are leaving thumb drives laying around in parking lots of companies and offices. You know, people take them and plug them in because they can't help themselves. They're curious. They want to know what's on the thumb drive. Well, their idea, if there's no label on it, is plug it in and take a look. Well, unfortunately, when they plug that in, they're inserting that malware onto their computer in the system. When it comes to these types, though, however, physical loss, we want to remember a couple of key things for mitigation purposes. One is encryption. All of the 48 states except one, flat out, if you have encryption, it is a flat out safe harbor. So if you have encryption on the device, you have no obligation to notify, you're golden. Tennessee has modified their statute a little bit, but it still works. We can still make the argument. But we always want to ask a few questions. And don't laugh, but you know, did the person have the password taped to the encrypted device, the thumb drive or the laptop? Or was it in the bag? We see this all the time. So we want to ask these questions. We don't want to just assume because something was encrypted that we are within that safe harbor. Did somebody log on and was the computer stolen after they bypassed the security? We see this and we call them our Starbucks cases, where somebody goes to Starbucks, they log in, they get through security, they go up to get their coffee, and they come back, and lo and behold, their computer is gone. And oftentimes they call and say, well, don't worry, it was encrypted. Well, the problem is you bypassed the encryption. We also want to the extent we can prevent people from saving things in these portable devices, we want to prevent them from doing so. Record management is also something critical that we want to be thinking about when we think about lost devices. The less we have on those devices, obviously, the better off that we are. Next, again, hard copy. And, we talk cyber. That's all you hear. And, I was laughing yesterday. I think it was during Jimmy Kimmel. They said, well, why is it that every time they show these cyber attackers, it's somebody in a hoodie hunched over a computer? So, we think cyber and we think data security, and we always think it's got to be electronic. But we can't forget about paper. It contains the same data. So we see a lot of hard copy issues, whether things are mismailed, misplaced, stolen, or they're not disposed of properly. So we want to make sure that we've got policies and procedures and training in place so that folks know how to deal with paper. And, we don't want to just save it all for someday. We want to properly destroy it. If we don't need it, let's shred it. And when we say shred it, make sure that you've got the company that comes to your office, somebody goes down with them, they actually watch the bin being dumped in and the paper being shredded. We've actually had cases where shredder trucks, quote shredder trucks, they're not shredding on site, are driving down the street and paper's blowing out the back. And of course, all their documents are blowing out the back. So we do want to be careful when it comes to disposal of paper. Next is unintended disclosures. And this could just be a misdirected email. You go to email someone, you start to type in their name, it self-populates, you are in a rush, you hit send, and you realize the minute you hit send that it went to the wrong person. There are things we can do to mitigate that, to reach out if that's a trusted individual and get something from them confirming that they have not misused the information, they have not forwarded the information, they're deleting it and emptying their trash. We want to make sure that's all done. Sometimes it could just be a computer glitch. There are certain computer programs that you can flip things on and off of, and we've had a number of cases where employees go on to look at their own personnel records or personal information, and as they're clicking through, all of a sudden it shows up that they can see everybody's personal information. So there's no bad person, but because of that glitch with the computer software, we now have an issue that we need to be dealing with. So we want to, from a mitigation standpoint, we want to encrypt or password protect files that are being emailed out. If we have to email, make sure they're protected. We want to make sure that we're testing our systems, that they're working properly, and to the extent there are vulnerabilities, we A, identify them, but more importantly, B, remedy them. Next, vendors. We are seeing a real rise in vendor issues. So, you may have some vendors that come in that have access to your system. They may do something wrong that results in a loss of data that you have in your control or that you've provided them. You are legally on the hook for that. So vendors and vendor contracts are very important, but we want to make sure that we are vetting vendors appropriately and that we've got appropriate contracts with them with appropriate language to protect ourselves. So we do need to make sure, and most of you may know, but the Target breach was the result of a vendor, their HVAC vendor, who malware was inserted onto the HVAC vendor system. The HVAC vendor plugged in to work on the refrigeration units at Target, and of course the malware was transferred from their computer onto the Target computer, and it got through their security, and here we are 4 years later, billions of dollars later in losses for Target because of that. So we want to make sure we've got appropriately vetted vendors and appropriate contract provisions. Next, the ones that will occasionally grab the headlines are stolen data by otherwise authorized users. Oftentimes you see this in the hospital setting. the snooper, the nurse that could not help herself and decided that she wanted to read about, Angelina Jolie's recent visit to the hospital. Even though she's authorized to be looking at patient records, she wasn't authorized to be looking at that particular information. Or we've had cases where authorized users knew they were going to be terminated or were quitting and decided on their way out they were going to take some data and try to hold the entity hostage. So we do see this, where people that have the authority to actually work with that data misuse that authority and go beyond it. And that's something that, again, from a training perspective, we just have to be prepared to deal with that. There's really no way to completely prevent that because they're authorized to be handling the type of information that they've subsequently stolen. But it is important to note that we want to make sure that people that have access to sensitive information truly need to have access to that data. It should really be on a need-to-know basis. So that is one thing that's very simple that you can go in and check. As people move around in different positions, what type of access do they have to data? If they don't need access to particular types of data, then they should not have access to that data. Next is clearly the one that gets all the press, which is what consumed last Friday, Saturday, Sunday, Monday, today, of course, is the unauthorized individuals that hack into a database or that insert ransomware. That's what we're talking about every day, day in, day out, because we're seeing quite a bit of this. And, this really comes down to two things. One, it comes down to your IT folks putting up as much protection around you, building that wall as solid as they can. But secondly, making sure that all of your people are trained and they're trained regularly so they know not to click on those attachments. Most of these instances are not because a hacker hacked through the system and did something. It's because somebody in the organization clicked on an attachment and did something they should not have, which resulted in their database or server being compromised. So again, we can't say it enough how important training is. You really need to do regular training with folks. It doesn't have to be super extensive, but you got to have constant reminders because this is not their job. But they need to be reminded that if they click on something mistakenly, it could have grave consequences for the organization. So this is a great stat, and we talk about awareness. So it's not just the individual's awareness. We also want to talk about organizational awareness. And I am fascinated by these stats. So companies, and this goes to how optimistic they are that they can detect an attack within their organization. Obviously, if you get hit by ransomware and everything's immediately locked up, you're going to know it. But when we talk about the variety of attacks that hit organizations, as you'll see, 60% of the organizations polled said within 72 hours or less, they would detect an attack. And then you see how it drops down to what I would call the most honest group, which is the last 20% that said they weren't confident at all that they could detect. Now, that's how they feel about themselves. Now, the reality is that it's a very small percentage of entities that actually figure this out. So only 31% of companies that have been attacked actually discover it internally, that they discovered themselves. 69% of the time, companies are being told by external sources, whether it's a customer, whether it's the law enforcement, the FBI, 69% are being told that they have a problem. So 69% of the entities don't even know that they have a problem. And what amazes me is the next stat to the right, which is how long it takes entities to discover this. The median number of days that a threat actor was present on a network before it was detected is 205. That's amazing. So that means these threat actors are getting in, they're sitting on systems, they're gathering data very stealthy, and they're doing bad things or waiting to do bad things, and they're going undetected for quite a while. And you can see that the longest presence that somebody actually admitted to was just under 3,000 days. So that gives you an idea of how sophisticated these attacks have become and how difficult it is to truly identify these attacks.
Next, we look at a study that interviewed about 3,000 individuals that actually received a breach notification letter in the mail. And not surprisingly, a lot of them, 60% there, said that it decreased the trust and the confidence in the organization. 15% would automatically terminate their relationship with that entity, and about 40% would consider terminating. The amazing fact there, too, is that third bullet there, that pretty much everybody, 94%, believe that whoever's reporting the situation is solely to blame for the breach. And this is a bit concerning because, as Jim was mentioning, right, the vendor has the breach. It's still on you as the owner of the data, that first party that takes in the personal information, to give the notice. And so we're seeing a little bit of breach fatigue, notice fatigue. Folks are just sort of reading them, scanning them very quickly, and throwing them out. And they're looking at, whatever logo or whoever's writing the letter to them, and they're thinking that that is the entity that is solely to blame, when in fact a lot of these, almost a third now, are the result of the vendor having the breach. We'll talk later on about some things you can do to vet and assess vendors and properly manage your third-party risk. A lot of folks, too, also think that the breach notice itself is another scam, another potential source of a continuing breach, especially when we see it in email, when there's links and things to click. You're already telling someone that their information has been compromised. They're very hesitant to be reading it and believing that it's genuine, authentic, and they're certainly not going to be reading it as they should. And so we really prefer to send letters that look professional, look the way in which you would send any other notification as opposed to email. But there are often times where our clients don't have addresses, so we have to do media notice, we have to do email notice, and in those cases the breach becomes a lot more widespread and publicly known. So as we indicated earlier on today, the definition of personal information differs in all of the states, and so too does the definition of what exactly is a data breach. And that's why we want to be really careful, and we'll remind you constantly here, is that we stay away from the B word, right? We don't call it a breach because, again, that is a legally defined term, and until you conduct a proper forensic due diligence, you analyze the situation under the statutes, only then can you really determine if you have a breach or if it just remains an incident or a situation. And so the definitions vary from state to state. Typically, we have an unauthorized either acquisition or access or use. Sometimes you have to have all of those, sometimes just one of those. Of PII, it's unencrypted, as Jim mentioned earlier, right? We have a safe harbor if the device that's been stolen or compromised or lost is properly encrypted. We don't have to give notice then. So we have a unauthorized acquisition, access, use of PII, unencrypted, compromising the security, confidentiality, or integrity of the data. And once you get through that, then most of the states also have what they call risk of harm threshold. So even if you have an unauthorized acquisition or access or use of information, it has to also trigger the risk of harm threshold in the state. So it's a breach unless there's no misuse of personal information, unless no reasonable likelihood of harm, for instance, unless there's been a financial loss or injury. And so again, this sort of really just continues to underscore the fact that we want to make sure we don't call it a breach until we really look at all of these statutes and truly determine that we have a breach. And if you haven't heard it enough, here's another slide on it. But even when we have a breach, we're very careful to not actually use the word breach in our notifications and our media releases. There's only one law, one state law, that's California, that does require us to use that word breach. Otherwise, though, we really have no obligation to call it a breach in any kind of notification. We can continue to call it a privacy incident. The word breach is picked up often by media outlets and picked up on social media. So some other good reasons why we stay away from the B word. Not only do state laws differ with respect to what is PII, what is a data breach, but the timing differs. So that's why it's so important and critical that we determine what states are in play. Some states, again, 14 days, some 45 days. Some states require notice to their attorney general or to other state agencies. Not every state can we send the same sort of letter and correspondence, because every state breach notice law has some very specific content notice requirements. So we'll have to change those up. So we often have multiple letter versions for just one breach. We often hear, oh, let's just email this to everybody. Oh, that sounds great, but if you're going to take advantage of what they call the substitute notice, you have to email, put it on your website, and do a statewide media blast. So we really prefer to send letters in the mail if we have addresses. Same thing with regard to states. If we have any sort of international individual residents that have been affected, we have to look at that country of that individual and where they reside to determine what notice requirements from an international perspective. Very quick high level on PCIDSS. Again, this was established early 2004. This is brought on by the card brands, the Visa, MasterCard, Amex, and Discover. It's a private standard. They can do whatever they want. They can fine, penalize whatever they want, and they're their own self-governing body. But all merchants, so anyone accepting, processing, storing, transmitting credit card data. So even if you use a third-party portal for some sort of payment, right, on your website, depending on how that is configured, you still could be determined as a merchant and have to be PCI compliant. There's a lot of misconception out there. Oh, well, we use a third-party processor to do all of that. Well, there is probably, more likely than not, a second or half a second where that data actually is passing through your network, and you arguably are the merchant that transmit, processes, stores, or maintains card data, and therefore you are brought into the realm of PCI DSS. And so it's important that you go back, figure out exactly, if you do take credit cards, how exactly that is processed on your site or within your brick and mortar, and figure out if you do have to be PCI compliant or not. You don't want to figure out once you have the breach, because that's when they really can come down with the hammer and fines and penalties.
So as we talk about all of the badness out there, the fines, the penalties, all of these things that can happen, what should you be doing from a proactive stance to try to minimize the likelihood of this happening, or at least minimizing the repercussions if it does happen? We kind of stopped using the "it's not a matter of if, it's a matter of when" phrase just because we were so sick of everybody saying it, but the reality is that's the reality. So what can we do to minimize risk and exposure? So the first thing is creating a written information security program, and that's actually required by law in a number of circumstances. But a WISP is a real good 6-7 page summary of what you're doing to protect your organization. And it lays out some of the security features, et cetera. So it's a nice internal document, but again, required by law in certain circumstances. And if you have an issue, a regulator may ask to see a copy of the WISP. Next, something that every organization absolutely, again, must have: an incident response plan. Again, required under certain circumstances, but really from a best practices standpoint, it's almost negligence if you don't have one. And it doesn't have to be 1,000 pages. Hey, it doesn't even have to be 100 pages. But we'd recommend larger or longer than a bar napkin. We've seen those, and we've seen the 1,000-page versions. So really, based on the organization and the level of sophistication and how complicated it is really going to drive that incident response plan. But there are some very basic things that should be in there. We work every day with organizations to draft those to make sure that they work for the organization. And this is really, and it should be, a living document, something that you're constantly updating and reviewing at least on an annual basis, because you should have the individuals that are on your incident response team and all of their contact information in there. So you review it at least once a year to make sure it's updated. We also want to make sure you've got carefully drafted confidentiality agreements for employees, vendors, and visitors. Very important that people understand how sensitive and important this data is and what they can and cannot do with it. It really starts at the time someone's hired, but if folks are already in the door, doesn't hurt to go back, have people sign confidentiality agreements. Same with vendors and visitors. As we've mentioned throughout, proper and ongoing training of employees on data security programs and cyber awareness. Again, just being aware of the risks and what they should be doing, just the basics, goes a long way. Perform a data privacy review and risk assessment, including penetration testing. If anybody wants it, it's free. The review is free. We send that out to hundreds of, probably thousands now, of organizations a year. And it's a little questionnaire. It's about 5 pages long, and it asks many questions, probably about 40 questions. But it really starts to get at a couple of basic questions. What do you have data-wise? How is it stored? And who has access to it? So we start to ask and answer those questions so that you can wrap your head around where you might have vulnerability. So we can, of course, provide that. And again, it's free. We just want to help people educate themselves and make sure that they're thinking about these things. And then the employee exit process. We need to make sure that you're taking a holistic view of data privacy and security. It's not just an IT issue. It's not just a legal issue. It's not just a risk management issue. It's not just an HR issue. It's all of the above, really. Everybody's got to work together and play a role. So exit interviews are very important. When people are leaving, have we asked the specific questions of what information they may still have? If they're walking out with a smartphone, is sensitive data still on the smartphone? Did they use their own computer? Do they have boxes of data in their trunk or at home? These are all things that we see all the time, but you're not going to know that and be able to protect yourself unless you ask the questions. So exit interview process is very important. Something else that goes hand in hand with that is just data destruction and disposal. Currently, 32 states require by law that you are properly disposing and destructing of data that you no longer need for a legitimate business reason. Now, we're all pack rats. We all keep everything because one day we might need that piece of paper. But the reality is, by saving all those pieces of paper, we create tremendous liability for the organization. So we want to make sure we're only keeping what we absolutely need and that we're properly destroying the things that we don't.
I had mentioned earlier about making sure we have a team in place and a plan in place. Well, these are the various stakeholders that we like to see on the incident response team. And obviously, it's going to be entity by entity, case by case. And not every privacy security incident situation are going to involve all of these areas and all of these stakeholders and decision makers. But we want to make sure that you have legal and IT and risk. One of the areas that's often missing is HR, and if we go back to the beginning of today, remember, right, that most of the time these are attributed back to human error, employee negligence, recklessness, gross negligence, recklessness. And so we want to make sure that we have HR looped in, not only from a communication standpoint, but that we're not terminating an employee for violating a policy too soon, because that employee may be the only one that actually knows anything about the situation. So we want to make sure HR is involved, certainly PR and communications, and your third-party external sources, right? Legal counsel, forensic services, mailing and call center and credit monitoring, all of those external providers, vet them now while things are calm so that, if, again, not if, but when, you have those relationships already in place and you're not having to negotiate contracts and meeting your forensics firms and your privacy counsel for the first time during the middle of the incident response process. The incident response plan, we're not looking at an 80-page plan, but it needs to probably be a little bit more than a bar napkin, and we have seen both of those. So we always say between a bar napkin and 80 pages. But this is your go-to document. It's going to outline who's on your team, what exactly is your escalation and notification process, your various decision points, and it's a really good place, again, to document all of your team members and to have incident logs in there. So even if it doesn't rise to the level of a breach, you have it documented that you did your due diligence and investigated the situation. Some other privacy policies, and these are things that regulators are looking for, certainly having an electronic computer device usage policy. As Jim mentioned, document retention, destruction is so important. Bring your own device. More and more organizations, entities are allowing employees to use their own device, and they are able to download the app and have email of the entity on their device. Well, what happens when they terminate? We want to make sure that we are able to get that information back. Telecommuting, social media, again, all good policies to have to the extent you don't. we're happy to direct you to various resources. Website privacy policy and terms of use, those are continuing to get scrutinized by the regulators and the plaintiffs' class action lawyers. To the extent you have a privacy policy on your website, want to make sure that you're actually doing everything that you're saying you're doing. Because if you're not, it's deemed to be an unfair and deceptive trade practice. FTC can go after you. Again, it's a really good source for plaintiffs' class action firms to go after as well. And so the rule of thumb there is if you're not doing it, it's better to remove it, delete it, rather than have it in and not be doing something. So if you say you're taking the following X, Y, and Z steps to protect information that you gather on your site, want to make sure that you are doing X, Y, and Z. Vendor agreements. It's so important that you go back, figure out when you're doing that sort of assessment, as Jim had talked about where is your information, who has access to it. Figure out what are all the third parties, all your vendors and service providers that have access to this information or that have acquired this type of sensitive personal information. And for those that you have identified that have that, take a look at your agreements. You probably don't have too much in there because they're legacy agreements and this stuff wasn't even around when you entered into those agreements with those service providers. But go back, take a look to the extent you need to do some amendments of those contracts and agreements. Make sure that there are specific provisions in there about compliance with data privacy standards. Make sure there's some mention of what is going to happen when the contract terminates. What about when that vendor passes on your personal information to another sub-vendors? What are the provisions and privacy standards in place as the subcontractor and third and fourth subcontractor continue to receive that information? Because remember, no matter where in that ladder of information being passed on, it's always going to go back to the owner of the data, the first party that received the information. So even though the vendor or the sub-vendor or sub-vendor has the breach, it's going to come back to the owner. They ultimately have the obligation. The most important provision is that you have a notification provision. So when there is a privacy incident suspected at the vendor or the subcontract vendor, that they give you notice within a day to 3 days max, so that you can conduct your appropriate due diligence and investigation. Oftentimes, their vendor is deemed to be your agent, and so you can't argue if the vendor waits 30 days. Oftentimes, we can't argue and say, well, our clock starts now. We have another 30 days. We assume their timeline as they are often considered our agents. So it's important that we have a contractual provision in your agreement that requires them and obligates them to let you know of a security incident within so many hours and days. We're going to go through some trends, some real-world examples now, both within the public entity space and then just some other breach examples. You know, we kind of talked about some misconceptions along the way. I think the biggest one within the public entity space is, again, this doesn't apply to us, and that is certainly a misconception. Again, it certainly applies to public entities, to agencies. And again, you have a separate provision oftentimes within these state statutes, so it does very much apply, and there is not immunity with regard to breach notification statutes. We continue to see a lot of unsecured wireless connections, and the lack of encryption from the device standpoint, USBs, desktops, laptops. We continue to see that lack of encryption, and the regulators really hate this one because they see that there's a clear-cut remedy that can be implemented, and that is just deploying the encryption. And so, again, regulators really don't like when they have to hear about a breach as a result of an unencrypted device. We talked about sort of the weak, ineffective passwords and weak physical security, and the lack of vendor controls. Again, as we talked a slide before, making sure that we have vetted not only internally, you could have the best security, you could be doing all the training, all the right things internally, but when you pass on that information to a third party or vendor or service provider, all of those safeguards really go out the window. So we want to make sure that we're properly assessing our third-party risk and our vendors. A couple of interesting examples. This was the Wisconsin Department of Revenue. So there was an annual sales report. It contained SOCIAs and tax ID numbers for anyone that bought property in Wisconsin for about a 3-month period. And although it was meant for a small group of real estate professionals, as often happens, this stuff just pops up online, and via a Google search or Yahoo search, we're able to locate names and SOCIAs. Unfortunately, with something like this, right, we know if it was accessed, so here, right, they accessed it 138 times. We don't exactly know, though, what social security number, what name was actually viewed and acquired. So you end up having to do, an over-notification. And here, that's exactly what they did. They had to notify 110,795 individuals who had made real estate transactions and sales. And again, most of those probably weren't even susceptible to the breach. They weren't acquired, weren't viewed, but were not able to tell because this information was inadvertently disclosed on the web. This is a great one, the New Hampshire Department of Corrections. So a staff member there found that a cable line was hooked to the computers used by inmates and then had been connected to a line that was linked to the prison system. Long story short, it allowed one of the prisoners to view, steal, and even change sensitive data, and including parole dates and sentencing dates. Not a good thing to change. Information from the management database system and the corrections officer offender records and info system was also compromised. So something like this, right, certainly rises to the level of personal information in the breach laws, but from a PR and communication standpoint, this certainly ran havoc across the state there and the Department of Corrections. In Baltimore County in Maryland, this was a contractor who had worked for the county, had no longer worked for the county, but it was, kind of going back to that sort of termination and exit process, making sure that any information that's been passed on to a former employee or to a contractor that we no longer work with, that we get the data back. Here there were 12,000 county employees that this contractor had personal information saved on a computer. And it was unrelated to work, and employees had their direct deposited information rerouted. There was over 6,000 individuals who were affected here, and 5,000 county hard drives were cleared of related data. So again, it's important that we are conducting that proper vetting of our contractors and our employees, especially when we no longer have a relationship with those parties.
Some other real-world examples, and these, again, are just a good thing for us to keep in mind. Donation of CDs. We literally had a brain surgeon who thought it would be a good idea to donate some supplies to a children's art project, and the donations included CDs from the hospital, which unfortunately contained patient information. So that became a very large investigation that went on for years. Hacking of databases that contain checks. We've got clients that scan checks in for various reasons, and they retain them. And if that database gets hacked, of course, which it did, now they've got to be notifying all of these individuals that their bank accounts may be compromised, and they need to reach out to their banks to take care of that. We've seen inadvertent emails to all users where everybody is getting sensitive information instead of it just going to one or two people. Compromise of login credentials. We've seen quite a few of these cases where login credentials are compromised. The hacker gets a hold of those login credentials and is able to come in as someone else and be in the system for quite some time before anyone knows it. The theft by HR employees. Here we had a situation, actually we had a couple, where folks in HR were actually selling off data, and it was brought to the attention, to their attention by the FBI, who saw some common threads, and as they traced things back, they were able to kind of triangulate and notice that there were different sources selling data coming from the same organization. So ultimately, they were able to catch these folks, but this is a problem that occurs more often, unfortunately, than we're aware of. Shared drive incorrect permission settings. This is one where the settings for a shared drive are incorrect, and somebody, again, has access to information that they should not. And we've seen this in many settings. Oddly, often, many of these cases have been in higher ed. And as a result, folks that should not have access to sensitive information do have access to it, which creates issues. So these can be very long, drawn-out investigations when, if there would have been a little more time spent on the front end to be a little proactive and careful, they could have avoided these situations. Next is a stolen laptop and unnecessary media notification. Again, when something bad happens, you want to conduct an appropriate investigation. Here, the client went straight to the media, and it became a big news story and cost them millions of dollars unnecessarily. The laptop was recovered. No one ever had it. So we really want to make sure that you follow that protocol set forth in your incident response plan. The thumb drive bull, another great one, New York City, in one of the large high-rise buildings. Two thieves came in and put a thumb drive bull on the security guard's desk and said they opened up a PC shop down the street. They wanted to do a little free advertising. They were giving away free thumb drives. Everybody took them, plugged them into their computers, and of course, they were loaded with malware that allowed these two individuals to access all the computers that used the thumb drive. So they were able to get into everybody's computers. Card skimmers, we still see a lot of these, whether it's at ATMs, gas pumps, especially personally when you're out using, your credit card, obviously, or your bank card. Be aware of them, yank on the device a little bit, make sure it's actually part of, whatever it is you're using, the ATM, the gas pump. Payroll vendors, we've seen a lot of payroll vendors that have been hacked into, and as a result, it affects their customer base. So we've seen quite a few of those in the last couple of years. We just are getting through with this year's W-2 season, W-2 scam season. So we see a lot of phishing emails that appear to come from executives saying they need all the W-2s, and somebody in the organization is in a rush to please the CEO or CFO and sends out all the W-2s. Well, of course, they sent them out to somebody who was a criminal, and before you know it, fraudulent tax returns are being filed within 48 hours. And finally, as mentioned, ransomware attacks. We have seen a huge uptick in the last couple of years. If you are a victim of a ransomware attack, get with a professional. Do not just try to pay it. Do not try to get the decryption key yourself. There are ways to do this to help you avoid becoming a repeat victim. So there's a lot of different things that can be done, but you don't want to be trying to do this on your own. We employ technical forensic specialists that work with us to deal with ransomware situations. So you want to make sure you've got the right people dealing with it.
Yeah, just a little bit more on ransomware. It's expected to be $1 billion industry for 2016. And we've really shifted. The hackers used to, steal the data, then sell it on the dark web, and that's where they made their money. Now it's really just shifted to early on in the process, and the hackers don't even need to take your data. They can just extort you and make the money that way and not have to sell the data. So it's a lot easier, a lot quicker buck, and it's untraceable. Certainly the WannaCry on Friday and over the weekend hit not too much here domestically, but certainly 74 different countries were confirmed to have been hit, hundreds of thousands of entities. And so that was a really good example of how the hackers can exploit many, many systems at once. And I do think they're going to continue to try that, and I wouldn't be surprised if it moves here domestically. Here's just a graphical representation of the types of ransomware, and it's really important we look at the variant of the ransomware, because that's what's going to tell us about the characteristics of that ransomware, whether it has the ability to exfiltrate, to export, and to acquire personal information. So up until 2016, there were just a few different variants. In 2016, we just saw all kinds of variants hit, and of course in 2017 we're seeing additional variants. Phishing attacks, as Jim had mentioned, this is the CEO, CFO sending out an email, kindly send all the 2015 W-2 PDFs. This is something you can really reduce with ongoing training. LinkedIn, another great source of phishing attacks. Everybody wants to connect with Bill Gates. He wants to be my friend. Unfortunately, it looks great. You click on that link, and it even goes to a landing page of LinkedIn. Unfortunately, you haven't connected with Bill Gates. You've connected with the hacker who now has access to your once secure networking system. We're going to talk finally about the breach response process, what exactly you do when an incident occurs. This is a simplified view, 4 phases here: discovery, investigation, response, and defense. And that 4th phase, defense, you're never going to eliminate that, but you really can reduce the risk of that, of class action lawsuits, of penalties, of fines, of reputational damage, and loss of business and income loss, if you do a good job with phase 3, and that is the response. So a good phase 3 results in a reduced likelihood of the phase 4 exposure.
And giving our timing, we'll go through this quickly, and the slides will be made available, but once an incident does occur, what do you need to do? So as part of this incident response plan, you want to put your carrier on notice if you have one, the carrier, the broker, the pool on notice, right? You want to let them know that you have an incident that you're investigating because these things move quickly. You want to engage privacy counsel, a breach coach, not the person that does your corporate work or real estate or someone you know that does trust and estates. You need to get an expert in this particular field that can communicate with you, that can make sure that things are privileged. You then want to get your incident response team together, and if you haven't already done it, you want to make sure you've got a leader on that team. You want to gather and preserve evidence. Oftentimes we see the IT folks trying to figure out what happened and in the process destroying valuable evidence. So we want to make sure that we're gathering and preserving evidence, not destroying it. We want to make sure that somebody in the group is actually taking notes and documenting what you're doing. Those notes should be per the request of the attorney and to the attorney so that we can argue that they're privileged. If needed, we engage a forensic specialist. We do that as the attorneys, that again, we can argue that whatever they discover is privileged. Depending on the circumstances, we would consider, do we contact law enforcement? And if we do we contact local law enforcement or do we contact the FBI? And that's very factual dependent. We need to determine if notice has to be provided by law, or is there a business reason to provide notice? And then again, we want you to work with your breach coach to craft the notification to make sure that it's compliant with the state law. And what's critical is you may say, for example, well, you know what, I'm in Tennessee, so I'm just going to look at the Tennessee law. The problem is this type of law across the country, you have to look at the state of residence of the affected individual. So the state of residence of the people that might be impacted. So typically we're looking at many, many states' laws, and they're all different. So we can't just rely on one typically, but we do need to know quickly where do the potentially affected folks reside so that we can look at their particular state laws and figure out what all we need to be doing. Next, if we have to notify, you want to work with your breach coach to notify the affected individuals, any regulators, state AGs, federal agencies, etc. There's a whole laundry list you'll see of folks that may need to be notified, which is why you want to work with somebody that's done this many, many times. Again, you want to coordinate with your breach coach and crisis communication folks to manage public relation issues. It may be somebody internal, it may be somebody external. We work on many media statements and frequently asked questions documents to make sure that appropriate communications are available and being provided. To the extent that we're doing this internally or externally with a call center, we want to make sure that callers are getting people on the phone that can actually explain and answer questions. So very important that whether it's internal or external, that those call center folks are trained appropriately. Next, offering the appropriate remedy to affected individuals. The knee-jerk reaction is, well, let's offer credit monitoring to everybody. Well, if someone's social security number is breached, that's appropriate, but it's not appropriate for every breach. So there's different remedies that can be offered, and you really need to make sure that it's tied to the particular facts of the case. And when we send out these letters, we always mention minors and deceased because they actually get different letters than a living adult. So we want to keep that in mind as well.
And after we give notice to the affected individuals, we have to give notice to many state regulators. Half the states now require that either state AGs, state police, Office of Cybersecurity for various state requires notice. And so they want specific details, how many individuals are affected, and they always want a copy of the letter. And in many states, there's a timing issue too. We got to give them a heads up before we give notice to their residents. And as we've been mentioning all day, right, the regulators, what do they dislike? The unencrypted devices, those default passwords and user credentials, lack of training, and lack of policies, procedures. And then when you do those penetration testings and those risk assessments pre-breach, right, we're identifying what gaps you have. When you fail to address them or have a mitigation plan in place, that's another area where regulators really come down with the hammer. Some final reminders with incident response. Just keep in mind, from that very first data discovery, we want to make sure that we're always keeping in mind the high likelihood of any kind of regulatory investigation, single plaintiff, class action. Avoid that breach word. Pick up the phone. Don't email. And make sure that we're directing all correspondence to counsel so that we cloak everything we can, arguably, with the attorney-client privilege. So, happy to take questions at this time.
All right, thank you so much, guys. We actually do have a few questions here. The first question, what do you, when you were talking about the confidentiality agreement, you said visitors should be included. And can you clarify a little bit more what you mean by visitors?
Sure. When we have individuals that are coming on site that might be walking around or potentially view sensitive information, we want to make sure that they're signing something, or we might just be disclosing information to them. We want to make sure that they understand certain things that they may see or are discussed are confidential, and we want to make sure they understand that that's not to be disclosed outside of that relationship.
Okay. Thank you. And then the bulk of the questions we received actually were questions about access to some of the information that you talked about. So you talked about a list of 40 questions, a document for data privacy review, terms of use, and possibly a bring your own device policy template. So is there a way that participants in this webinar could access any of those resources you mentioned?
Sure, we'll be happy to circulate the data privacy questionnaire and review along with the slides, and that will really help sort of determine where there may be gaps, things that the entity does need to have in place.
Fantastic, thank you. And then we've just had one more question come in while you guys were answering those other two. And it is, I've heard that you never pay ransomware. Others say you should pay it. Is there a rule of thumb on this?
Yeah, it's kind of interesting because the FBI came out about a year ago and shocked the world and said, you know what, if you can't get your data anywhere else, you better pay the ransom, which we were stunned that they would endorse paying that type of thing. But what ransomware comes down to is when your data is encrypted and you cannot get it unless you pay the ransom to get a decryption key, what really is going to make your decision, and quite frankly, easy is a couple of things. One, do you have a backup of the data? If you have a backup, then you don't need to pay the ransom because you have the data. Now, somebody might say, well, I still want to get all my original data back because I don't have it all. Well, if you've got a good backup, then you don't necessarily need to pay the ransom. The other issue is just we see oftentimes entities will take a very moral stand and say, well, we're not going to pay it because we don't want to fund this type of, quote, terrorism. That's an organizational decision. At the end of the day, it comes down to, do you have a backup of the data, or how much will it cost you to rebuild the data that's been encrypted? If it's going to cost you $1 million to rebuild the data and somebody wants 3 Bitcoins and only wants a couple $1,000, you might say, I'm going to pay the couple $1,000 and try to get the decryption key and move on. So those are it's very factual, but those are kind of some general parameters.
Okay. Are there any other questions while we've got these guys on the line? All right. I am not seeing anything come in. So with that, thank you both so much for your time. Appreciate the presentation today. Participants, we will be sending the slide deck in the next coming days, and the recording will be available on the A Group website. And thank you, everyone, and have a great afternoon.